For those of you who fear you may never get an H-1B, it is a lottery-based system after all. Well, O-1 visa can be an option. You can also be on other visas and think of O-1 visa, and you might actually find that this particular visa is actually easier and will help you navigate the US immigration system. There is a caveat though, there are no free lunches. The caveat is that the eligibility requirement for an O-1 visa is much stricter. The requirements are much stricter as compared to other visa categories. But if you do qualify, you will be labeled as an extraordinary alien by USCIS. So if this is something that fancies you, continue on our discussion today where me and partner attorney Min Kim, who will be joining us from our Edison office, we will be talking about O-1 visa eligibility and EB-1 extraordinary ability. Hello and welcome to Thursdays Live with Chugh. My name is Neha Mahajan. I'm the Business Development and Outreach Manager here at Chugh LLP Attorneys and CPAs. And please join me in welcoming partner and attorney Min Kim, who's joining us from our Edison office. Hi there, Min. Welcome.
Thank you for the warm introduction, Neha. I'm happy to be here with you.
Always a pleasure to have you here, Min. All right, so let's just start with the very basics, right? Not too many people really know about an option that exists for them, which is called the O-1 visa. And also EB-1A, which is for the individuals of extraordinary ability. Can you tell us more about both the O-1 visa and the EB-1A, and why should anybody who's a non-citizen, why should they care?
Right. So, perhaps, an explanation to why it might not be a heavily relied upon visa classification, as you kind of introduced us to. First of all, it is rather strict in terms of qualifying criteria. How the visa classification is defined. It was intended by the lawmakers, by Congress, so that not a lot of people can first qualify for it. But also, in addition to that, there are specifically carved out industries and fields, primarily science, business, education, athletics, and so on, where individuals can potentially qualify for the O-1 and the EB-1A for extraordinary ability aliens. So, there's some room to maneuver around those definitions. But just because someone might be, let's say a standalone engineer and they've been an engineer all their life, they might want to kind of consider, do I qualify for an O-1? Do I qualify for an EB-1A? And I suppose just the nature of their of what they do on a day in and day out basis might not necessarily include them within those specific categories. But with that said, for those individuals who might work in the sciences, who might work in education, who might work in business, the O-1 and the EB-1A, the green card parallel to that, might be potential options. And I think it will be helpful just to kind of perhaps shed some light on how the O-1 might be a little different, some of the options that it might present, and comparing and contrasting it to other more popularly used visa classifications like the H-1B and the L-1. So you kind of referenced it earlier. I suppose one of the main limitations to the H-1B program is that it is lottery based. 65,000 for H-1B regular cap, 20,000 for U.S. masters, qualifying U.S. master's degree, earners there. So there are some built-in limitations, and not everyone kind of makes it in the lottery. 1, 2, 3 bites in the apple, and someone's registration is still not selected. So the O-1 is not lottery based, and because it's not lottery based, since there's no cap on it. If someone is eligible, they can look to change their status to an O-1 visa holder anytime during the year. There's no, artificial built-in government filing periods. Everyone's kind of familiar with the March registration and how USCIS starts taking, H-1B cap petitions in April. O-1's not restricted, time-wise. from January to December, it can happen, provided that the eligibility criteria is there. For I suppose another fairly common work visa category is for L1s, for intercompany transferees.
Mm-hmm.
Yeah, L1s don't have a cap, unlike the H1B, so it shares that commonality with O's. But for someone to be qualified for an L1, they have to be working abroad for at least 1 year with a qualifying organization. So, we have some, highly qualified individuals working in the sciences, working in business. They're at the executive level, manager level, and for all intents and purposes, they're extraordinary. But the fact that they haven't been working for 12 consecutive months abroad at the company's affiliate overseas, whether it be India, China, what have you, it kind
Right.
of includes the L1 option. So there's a built-in limitation there. And that's not even taking into account, other national-based, visa classification like the TN, which is reserved for Mexicans and Canadians, and the E3 for Australians. So the O1 is a little bit more flexible, kind of given that it is free from those limitations. But with that, there are some, pretty exclusive criteria that individuals do have to meet. Primarily, there are 8 contributing factors listed for the O1, and
Right.
there's 10 for the EB-1 extraordinary ability. So there's a lot of overlap between the O1 and the EB-1. So we can talk about those two together. I suppose the 2 additional factors for EB-1 is that there's some additional factors for artists, but for all intents and purposes, there's a lot of overlap there.
All right. Wow, that's a lot of information there, man. Right at the onset, and the criteria also sounds really, really challenging to me. I'm still kind of trying to wrap my head around this entire extraordinary ability concept as well. Do you think you can perhaps help us break it down even further? And are there any practice pointers? Are there any tips really that you can recommend to those, who want to apply for an O-1 or the EB-1A, and they're looking to file a petition with USCIS? What should they know?
Right. That's a good point. It's I mean, because it's not a heavily used visa classification, the O or the EB-1 extraordinary ability. Perhaps let me start by defining the terminology of what the immigration regulations say that someone who is qualified to be extraordinary ability caliber, and then we can talk about those factors, and perhaps I can recommend some practice pointers
Sure,
for
that'll be great.
individuals who might want to kind of explore this. I suppose I took it straight from the regs here, the regulations. So an individual who is considered an O1 qualified candidate is an individual who has extraordinary ability in the sciences, arts, education, business, or athletics, which has been demonstrated by sustained and national or international acclaim, and who is coming temporarily to the United States to work in that area of extraordinary ability. And then there's a separate definition and carve out there for individuals in the motion picture and television industry as well.
Yeah.
But I suppose for all intents and purposes, the one thing to kind of glean and extract and take home here is that the person who is being sponsored for an O1, they do need to come to the U.S. to work in that field. Let's say we have a beneficiary, they meet all the criteria for the O1, but they're intending on coming to the U.S. to work in an entirely different operation altogether that is
Right.
apart from how they qualify for the extraordinary ability visa. Then that might not necessarily work. They would have to be coming to the U.S. to work in that occupation as sponsored by the extraordinary ability employer and petitioner, whether it be in that occupation or in a related field. So I suppose that's something to kind of bear in mind for future candidates looking to explore this. How you are considered to be extraordinary overseas.
Mm-hmm.
Will you be doing that extraordinary thing here in the U.S. once you're admitted, as an O1 extraordinary ability,
Right.
alien here? And so with that, some practice pointers to kind of help the audience here. I mean, I'm not going to go over the entire extensive list
Right.
of the eight prongs and the eight criteria, but some quick takeaways. The regulations, they kind of reference awards, any kind of major awards, or perhaps a minor award that the person might have received, pertaining to their national or international recognition. One thing I found in my practice is that any kind of school issued award, USCIS discredits. Let's say that someone got a full ride, a full scholarship to, a fairly prestigious university, and they're like, oh, man, I have this, scholarship here. I have this, this grant from whatever institution. That's technically an award, isn't it? And what I would try to say, kindly, is that this is very impressive, but for all intents and purposes, for the O-1, it'll be difficult to use. So any kind of school issued scholarship or award, kind of comparing and contrasting the ability of the beneficiary to other students, that's not to be used. And I suppose a common misconception regarding awards is that let's say the beneficiary was part of a group that received an award.
Right.
Can that group award be considered? And I would venture to say yes. If the group is, many in number, then perhaps that might be a reconsideration there. But if the beneficiary is, let's say, one of five or one of 10, and that 10-person team, they developed something that got national publicity or international acclaim, the fact that the person was part of that team and was a critical contributor to that team, doing whatever got that
Right.
national acclaim, that should be considered. So the fact that it wasn't your name specifically carved out into that award, that shouldn't that shouldn't make people hesitant to consider the O-1 visa category. I suppose another pointer that I can recommend is one thing that a lot of O-1 candidates who are looking to explore this kind of bring up with me is that, oh, I'm a member of a fairly prestigious organization. Well, the conversation cannot end there. What needs to be looked into is, how were you invited to be a member? Was it as simple as you pay the registration fee, you pay the annual dues, and you therefore become a member of that highly exclusive organization? But it has to go something beyond that. What's the membership criteria? And obviously, more exclusive the better.
Right.
Another thing to bear in mind for the O-1 and the EB-1 is that any kind of published material that someone has, if the person is the first or second author of that journal article that he or she might have written, all the better. If there's a group of authors, and if they happen to be, I suppose here sequence matters. Like first or
Yeah.
second author kind of proves that you are a main contributor. If you were the last author of that specific publication, if you were the last author of that publication, then I suppose it's an indicator to USCIS that you might have had a more minor role in
Right.
in that. So those are just some of the, some
Right.
practice pointers to kind of keep in mind. There's an extensive list, that I've come to know that in practice USCIS treats more favorably than not. I suppose just to kind of move on to the next item, is that a lot of beneficiaries, they try to get the O-1 approved by referencing their salary. And yes, there's a salary component. How USCIS determines it is that, oh, if the beneficiary for the O-1 case or the EB-1 case happens to make more in terms of base salary, in terms of whatever bonuses, compared to his or her colleagues, that might be a contributing factor in that person being considered for an approved O-1 case. I suppose my feedback to that is that it's not that easy. Just because you might be making more than your friend and colleague here, USCIS needs more than that. And I
Right.
typically like to use the salary component as like a supplemental kind of piece of evidence. I
Right.
want the person to first meet the three factor threshold that
Mm-hmm.
and say to USCIS, he or she who's being sponsored for the O-1, they already meet the other prongs to be considered extraordinary. And oh, by the way, they also have a very
Right.
impressive salary figure. So it
Right.
can be like kind of like the icing on top of the cake. But in order to kind of ground and prove your O1 case on the basis that you make more than your colleague,
Yeah.
that might be a losing argument.
This is all great information, man. And I'm sure anybody who's watching us right now and who's even remotely considering to be on an O1 visa, this is gold mine for them. You've really simplified so much information. I just want to reiterate, and this is a disclaimer, that the advice, there is no advice here. Whatever we're discussing today is for informational purposes only, and this discussion today does not create an attorney-client relationship. And also, you are watching us on YouTube, Facebook, and LinkedIn. Thank you so much for joining us. If you have any questions for us, we will be happy to answer them live here. So, Min, I just want to mention we are 16 minutes into our discussion already, and we haven't even touched half the discussion yet. So, very quickly, I'm going to go on to the next question, which is what are some of the advantages of, say, an O1 visa over an H1B? Everybody automatically just thinks of an H1B, right? Especially students who are here. And also for our green card purposes, what are some of the advantages into exploring EB-1A extraordinary ability classification?
Right, right. So just talking about the O1 versus the H1B, I mean, we kind of brought it up earlier, but obviously the main difference is the lack of cap.
Yeah.
So USCIS freely grants O1 approvals provided the beneficiary meets the criteria in being considered extraordinary ability according to the immigration regulations there. So that's the main difference. In addition to that, I suppose, one key thing is that the O1 can be extended indefinitely.
Mm-hmm.
So there is no, 6-year maximum validity period. I mean, I suppose depending on how educated, the foreign national might be and the attending audience, um, depending upon the country of birth and if a person has kind of gone through the green card process somewhat, there might be options to extend the 6-year H1B maximum to further years. But the O1 beneficiary does not have to rely on that.
Right.
The O1, once it's initially approved, it's approved for 3 years. And unlike the H1B and unlike the L1, the extension increments are 1 year at a time. So you get a 3-year initial approval, and let's say you look to extend your O1, and the activity and event that the O1 was approved for doesn't change, then you'd be granted a 1-year extension by USCIS. A caveat to that is that if you happen to look to renew your O1 and extend it by filing another visa application overseas at the consulate, you actually get a 3-year O1 approval. So that's a unique feature that USCIS and the State Department, they kind of approach it a little differently there. But yes, let's say that we have a standard O1 beneficiary. They got the approval, and they're looking to get the O1 extension. Then
Right.
it'll be granted in 1-year increments and extended indefinitely. As opposed for the green card, the main difference is that for the EB-1 extraordinary ability, because it's under the EB-1 preference category for priority workers, there's no backlog for if someone happens to be born in China or India. A lot of times those individuals go through the labor certification process and they get to a certain stage and they have to wait. So if someone is filing their I-140 petition and being sponsored for permanent residency by by the U.S. company, then they can immediately file to apply for the adjustment of status. And
Okay.
perhaps another key difference is that the EB-1 extraordinary ability is fairly unique in that you don't necessarily need a petitioning sponsor, a U.S. company, to file for you. There is a self-petition element that is available.
Okay, that makes it sound easier. We don't know how easy it is when you really are preparing all the paperwork. It's a lot of paperwork, right? So we do have an audience question coming in here for you, Min. And the question is, we see O-1 EB-1 expert opinion requests for stunt riders and tattoo artists and all of that. How does USCIS look into such kind of extraordinary ability petitions? Are faculty experts or just curious about it?
Right. So, I mean, if we're talking about tattoo artists, that falls within the the art element for EB-1 and O-1, and the criteria, the definition, in kind of laying out what USCIS looks for, improving extraordinary ability in the arts. I suppose, thankfully, it is somewhat reduced, compared to the more stringent categories for science and business. It doesn't mean that the artist has to prove anything less. Those prongs, meeting the 3 out of the 8, for O-1, and 3 out of the 10 for EB-1 extraordinary ability, that still exists.
Right.
But when it comes to showing sustained national and international acclaim, I suppose the standard of the type of evidence and the amount of evidence might be a little less, which is which helps these artists get these cases approved.
All right. What about stunt riders?
Stunt riders,
Stunt riders.
what's
Like I'm assuming that's what they mean. Folks on motorbikes who do all these
oh,
stunts.
okay,
I'm
right,
assuming
right,
that's the
okay.
meaning.
Yeah, so well, I mean, I suppose that might be a nice leadway into talking about the O2.
Yeah.
So the O2 is for the O2 comes in tandem with the O1. So the O1 is obviously for the alien of extraordinary ability, but in order to get an O1, and you see this mostly in the in the entertainment industry.
Yeah.
Let's say we have a main singer or a main dancer, and they have a troupe of dancers along with them, or we have someone in the motion picture industry, and they have their stunt team, and so if in order to get the O1 approved, and they have to come to the US in order to conduct their O1 activity, if they have to bring a team with them, those individuals can also be approved for the O2. They're not necessarily the the foreign national of extraordinary ability, because they can't prove that that they were nominated for whatever movie award, or they have all these different publications that were that were printed kind of referencing them. If anything, they're just a stunt double. But in order to get this activity completed, this movie that needs to be shot in the U.S., of course, the stunt team has to come with the main actor to the U.S. So the rules kind of define that. They carved out the O2 visa category, and those individuals might be able to be eligible for that.
All right. Thank you. This is all amazing information right now. So thank you for asking that question that came right from the audience. Now let's also talk about entrepreneurs, and just want to be mindful of the time. We are 7 minutes left into our discussion. So the entrepreneurs, is it true that entrepreneurs, someone, let's say, just starting out a business and is investing into the US economy, they might be eligible for an O-1 or an EB-1A, or perhaps such situations are really not covered by these visa classifications. What's your take on it?
Right. So we're talking about obviously extraordinary ability in business, and like the one in the sciences, it could be that a lot of the O's are filed within these two buckets. Someone who is claiming to be extraordinary in science or business. So USCIS, when they do receive an O-1, when they do receive an EB-1 extraordinary ability green card case, more likely than not, it's going to come from one of these two buckets. And because of that, they are rather, strict in terms of, what they consider to be an approvable EB-1 extraordinary ability in business case. The fact that someone might have invested into the U.S. economy, opened, whatever, business here, therefore created, jobs for both, U.S. citizens and foreign nationals here in the U.S. That in of itself I believe, doesn't qualify them for the EB-1, extraordinary ability, because the key point to kind of bear in mind is that it has to be sustained. That's written into the definition for an O-1 or an EB-1 extraordinary ability case. Is there a continuous record of that extraordinary ability activity, both overseas or if you happen to be in the US, here in the US?
Yeah.
So the fact that someone, one time might have invested into the U.S. economy, opened a business, created a bunch of U.S. jobs, well, it's going to be difficult to prove that sustained element that is absolutely essential in order to get these cases approved.
Right.
Now, if there's, history, if there's recent history that we have a major entrepreneur investing in these businesses, remediating them, helping them to survive, et cetera, then, perhaps if the accolades are there in support of that, if the beneficiary was, spotlighted in major publications, outlining his work, and he has a list of different acclaims and accolades that he can point to, saying that I have showed a history of sustained, international or national acclaim, then we can definitely look to file an O-1 case or an EB-1 extraordinary ability case for that person. But the fact that we have a one-time or maybe even two times of investment into the U.S. economy in an entrepreneur fashion, I suppose that's going to be somewhat challenging. But with that, I'll be remiss if I didn't kind of mention, there's specific visas within the immigration rules that do allow those individuals. So the parallel to that is the E2 for a treaty investor. If someone's background, if their country of birth allows for the E visa expiration there, then they should look into the E2 visa classification, or the green card counterpart to that is the EB-5 immigrant investor visa. So, yeah, I mean, that's outside of the scope of, today's, session. But
that can be a separate topic in itself. It's a huge topic,
right.
and we've touched some of it in our previous discussions. They're all available on YouTube. If you just YouTube Chugh LLP and look for e-visa, you'll find something on it from us.
Mm-hmm.
Yeah. All right, Min, we literally have 2 minutes, and there is an audience question coming in, and I thought I should ask you. Earlier this year, I filed to change my status from H-1B to O-1, and it was denied. The attorney I used can't explain to me why it was denied, as the expert reference letters that were included in the petition were super detailed and fully described how I met 3 of the criteria for the O-1. Do you have any recommendations on how to revise the case? Because I am looking to refile.
Right. I mean, the possibility of refiling is there, so that's good that this foreign national is considering that. I suppose what immediately comes to mind, and if I'm understanding the background correctly, is that maybe a lot of the O-1 was supported by these reference letters that this person is saying that it was done by the attorney that he or she used. So reference letters is good, but reference letters only does so much. Because reference letters, if you look at it, the O-1 regs and the EB-1 green card classification, the criteria there that every foreign national is looking to kind of comply with, nothing is said about reference letters. There's no expert testimonial letters that that USCIS requires, and because of that, all that's considered kind of like corroborating evidence, like supplemental on top of the primary evidence that should already be there.
All
And
right.
any attorney who knows what he or she is doing, they would do that. Of course, you would submit the prima facie primary case, and on
Right.
top of that, look to supplement that with additional supporting expert testimonial letters. But to bank the entire O-1 approval on just a bunch of letters, no matter how prestigious the letter writers are, no matter how well written those letters in fact are, it's going to be a losing case, because you still have to prove by independent evidence there that you were a judge of others' work, that you were, someone who published, persuasive materials that really kind of move the needle in terms of the industry that you're considered an expert in. So the letter should always be treated as something that can add to what is already an approvable O1 case, and perhaps this beneficiary can look to do that.
All right. Thank you for all that knowledge, Min. This has been wonderful. This brings us to the end of our discussion today. I'm sorry I can't take any more questions. We have run out of time. But if you do have any questions for us, and if you would want to speak with Attorney Min himself, info@chugh.com. That's info@chugh.com. So this brings us not only to the end of the discussion today, but also to the end of the season for Thursdays Live for the year 2022. We will be taking a break, and we will be coming back with a much better version of Thursdays Live in the year 2023 in January. So in the meantime, if you have any suggestions for us, you want certain topics to be covered, you want to reach out to me or any of the attorneys, info@chugh.com is your best friend. Just email us and we will get back in touch with you. So until next year, I would say, I'll see you around. Thank you so much. And thank you, Attorney Min. Thank you for joining us today.
Thank you, Neha.